आज जोराड लॉ के इस एपिसोड में हम चर्चा करेंगे फैमिली कोर्ट पर। मेरे साथ हैं मिस्टर विनय कुमार खन्ना, ए फॉर्मर प्रिंसिपल डिस्ट्रिक्ट एंड सेशन जज। फर्स्ट ऑफ ऑल, आई वेलकम मिस्टर विनय कुमार खन्ना. He is a known figure in Delhi District Judiciary. He joined Delhi District Judiciary in the year 1992 as a civil judge and promoted as a district judge in the year 2006. And he demitted the office in the year 2025. During his long tenure, Mr. Khanna worked in almost all the jurisdictions, and matrimonial disputes are close to the heart of Mr. Khanna. Welcome, Mr. Vinay Kumar Khanna ji.
Thank you. Yeah, you rightly introduced. I'll say apart from that, I also acted as a mediator.
Right.
And as a judge in charge mediation center, I assisted settling 1,000 of cases, and I was also a senior master trainer. So, thank you.
Thank you. आज हम बात करेंगे फैमिली कोर्ट के ऊपर। फैमिली कोर्ट का गठन सितंबर 1984 में हुआ था। इसका मेन एम और ऑब्जेक्ट था टू प्रमोट कंसिलेशन and to secure speedy settlement of dispute relating to marriage and family affairs for matters connected therewith. आज 40 साल बाद फैमिली कोर्ट के गठन के बाद आज हम चर्चा कर रहे हैं कि फैमिली कोर्ट का जो ऑब्जेक्ट था क्या वो अचीव हुआ, अगर नहीं हुआ तो कारण क्या थे और हमें और क्या करने की ज़रूरत है ताकि जो जिस मकसद के लिए फैमिली कोर्ट का गठन किया गया था उसको हम पूरा कर सकें। एज ऑन डेट दिल्ली में 12 प्रिंसिपल जज फैमिली कोर्ट हैंगे और 18 अलग से कोर्ट हैं, तो तकरीबन 30 कोर्ट आज दिल्ली में फैमिली कोर्ट फंक्शनल रहेंगी। मिस्टर खन्ना, मेरा पहला सवाल ये है कि फैमिली कोर्ट की जुडिक्शन क्या है और क्या फैमिली कोर्ट सिर्फ मैट्रिमोनियल डिस्प्यूट करती है या दूसरे डिस्प्यूट भी एडजुडिकेट करती हैं?
Right. Jurisdiction of the family court is described in section 7 and 8 of the Family Court Act 1984. It vests exclusive jurisdiction. It says family court shall try all suit proceeding relating to matrimonial relief, that is divorce, nullity, judicial separation, and restitution of conjugal rights, property of spouses, declaration of status, legitimacy, guardianship and custody of minors, and maintenance under section 125 CRPC. So, not only matrimonial cases but family court deal with all civil dispute arising from family relationship. And you see, duty of the family court is prescribed under section 9 of the act, which casts a duty upon the family court to endeavor to assist and persuade the parties in arriving at settlement. So, if we see how these courts are different from other court, in this family court proceeding may be held in camera at the discretion of the court or at the request of the parties. Section 11 speaks about it.
Okay.
Then parties are not required compulsorily to engage counsel to represent their matter. However, court can provide the assistance of a legal expert as amicus curiae. Section 13 is there for this. Now, technicalities of Evidence Act are not applicable to family courts. Section 14 is very clear about it. So, family court is not required to record the verbatim statement of the witnesses like other civil courts. On the contrary, court can record the substance of the statement of witness. Section 15 of the Family Court Act. Now, statement of formal witness can be taken on affidavit, section 16. So, we see these courts are different in these aspects.
ओके। खन्ना साहब, जो फैमिली कोर्ट का लेजिस्लेचर का पर्पस था फैमिली कोर्ट बनाते वक्त ये था कि फैमिली कोर्ट शैल प्रमोट कंसिलेशन इन एंड सिक्योर स्पीडी सेटलमेंट ऑफ डिस्प्यूट रिलेटिंग टू मैरिज। why matrimonial dispute need a speedy settlement or disposal? Because generally every dispute need a speedy disposal. Why the family matrimonial dispute need a speedy settlement or disposal?
Right. So I think I'll divide this answer in 3 parts. First is, what did the law says about this? You see, in 1984, Parliament looked at our civil code and said this is not working to the families. So, because in normal civil court, husband and wife are treated like two companies fighting over a contract. Cross-examination, public gallery, year of dates. But marriage is not a business deal. It's people, it's children, it's 20 years of memories. So the legislature wrote section 9 and told every family court judge, your first job is not to give a judgment. Your first job is to promote conciliation. Try to save the marriage. And if you can't, then give a decision last. Okay. So there were 4 reasons for this. First was save the institution.
Marriage institution.
Yeah, marriage institution. The state wants families to survive because strong family lead to strong society. So conciliation first because law, not advice. Number 2, protect the weak. Let's be honest. In most family fights, women, children and senior citizens suffer the most. A woman waiting 5 years for maintenance is not getting justice. She's getting destroyed. Stop the fight. The longer a case runs, the more hatred grows. Today it's divorce, tomorrow it's 498A, DV Act, custody, 125. So one problem becomes 5 cases. Speed kills that cycle. So dignity, number 4 reason. Family matters should not be fought like road rage in open court. They needed privacy, counselors, humanity. That was the legislature's purpose. Heal first, judge later, and do it fast. Then second segment is why speed matters so much. Now, why speedy settlement is not optional? Why it is urgent? Because delay in family matter doesn't just delay justice, it destroys lives. Emotional cost. Every date, every hearing reopens the wound. After 3 years, even if couple wants to reconcile, they can't. Too much bitterness. We lose the chance to save the family. Money. Imagine a mother with 2 kids, no maintenance for 2 years. How does she pay school fees, rent, medicine? That is why the Supreme Court got angry. Children. A child's class 1 to class 5 can pass while parents fight in court. You can give money later. You can never give back those 5 years. So, truth gets lost. Witnesses forget, people move cities, evidence disappears. Fast cases mean better facts, better justice. So speed is not about disposing file. Speed is about saving childhood, saving dignity, saving future. And now, briefly I'll touch about what the Supreme Court said. Supreme Court has said this again and again. Let me give you, if you allow 4 judgment, we should know, everyone should know. Mm-hmm. In case Srinivas Rao, DA Deepa, 2013, Supreme Court said marriages are made in heaven. Court must make every endeavor to preserve it. So don't be in a hurry to break. First try to join.
Okay.
In other judgment, Bhuvan Mohan Singh versus Meena, 2015, this was about maintenance. Supreme Court said, and I quote, delay in disposal of maintenance case is nothing but denial of justice to wife and children. They ordered all court to finish 125 cases in 60 days. Now, Amardeep Singh versus Harveen Kaur, 2017. This was about divorce by mutual consent. Supreme Court said 6 months waiting period is for conciliation. Mm-hmm. If you are already been separate for 2 years, forcing you to wait more only increases bitterness. Mm-hmm. Object is peace, not punishment. And now, Rajneesh versus Neha, 2020. Biggest judgment on maintenance. Supreme Court gave a format, timelines and said 60 days. That is it. Wife and children can't starve while the case is pending. In case Shri Devi versus Jaya Rajan, Supreme Court again reminded judges do settlement at every stage. That is what Section 9 demand. So the message from top court is loud and clear. So I'll say the message, if you are a litigant, come for resolution, not revenge. Use mediation, ask for speed, but also bring truth. The law is designed to protect you. If you are a lawyer, we are officers of the court. First, yes, fight hard, but also advise settlement when it is right. Stop asking dates for no reason in family matter. File complete paper on day one, because we are not just filing cases, we are shaping families. That is what I'll say. Thank you.
Mr. Khanna, whether family dispute also affect society as a whole? It has some impact on the society?
Yes, it has a profound impact, I'll say, on the society. You know, family dispute profoundly affect society as a whole because we know families are the foundational building blocks of a community, of a society. Now, what is society? Made up of families, individual. When individual family unit experience chronic instability, conflict or breakdown, the negative consequences ripple outward, creating massive economic, social and institutional strain on the broader public. Family dispute transition from private matters to societal issues through several distinct pathways. If I can break it again into 3-4 parts: economic strain and public cost. Legal system, you see, resources are reserved, are limited. Domestic dispute, divorces and custody battles overwhelm family courts, legal aid services and public administrative resources. So, welfare system, several family breakdown often force vulnerable members such as single parent or displaced youth to rely on state welfare, public housing and social safety nets. Workplace productivity, you see, reduces. Individual undergoing intense family conflict experience high rate of absenteeism, distraction and mental fatigue at work, costing business millions globally in lost productivity. The cycle of crime and public safety, juvenile delinquency, children from homes with high level of unmanaged conflict or domestic abuse are statistically more vulnerable to falling into substance abuse, gang involvement and criminal behavior, intergenerational violence. Exposure to violent or toxic family dispute normalizes aggression, making children more likely to repeat these behaviors in their own future families and neighborhoods. Homelessness, several family alienation or domestic abuse is a primary driver of youth and adult homelessness, which requires significant municipal intervention and emergency shelter resources. Now, impact on education and health care, school disruption. Children coping with toxic family environment frequently exhibit behavioral issues, low academic achievement, higher dropout rates, which lowers the overall educational standard of school. Now, mental health crisis, chronic family stress manifests as depression, anxiety and trauma across generations. This heavily burdens public healthcare system, emergency rooms and community mental health services. There's an erosion of societal capital, social capital and trust weak. Communities, when families are fractured, community cohesion declines. Neighborhood becomes less interconnected and voluntarism or mutual community support drops. Distrust in institutions. Higher rates of family disintegration often leads to a broader cultural cynicism regarding the stability of marriages, partnership and foundational social institution. So we see how profoundly it affects the society. Thank you.
खन्ना साहब, आपने सही कहा कि स्पीडी कंसिलेशन इज़ द मेन ऑब्जेक्ट और सुप्रीम कोर्ट ने भी इस पर जोर दिया है। और इसी बात को मद्देनजर रखते हुए फैमिली कोर्ट एक्ट में सेक्शन 3 कहते हैं कि स्टेट के ऊपर ड्यूटी कास्ट की हुई है कि हर 10 लाख की पॉपुलेशन पे एक फैमिली कोर्ट होगी। दिल्ली की पॉपुलेशन एज ऑन डेट अप्रॉक्सीमेटली बिटवीन 3.5 to 4 करोड़ हैगी और उसके नियर बाई इलाके हैं जैसे गुड़गांव, फरीदाबाद और नोएडा को मिला दिया जाए तो पॉपुलेशन अप्रॉक्सीमेटली 5 करोड़ बैठती है। तो क्या ये जो 30 नंबर की जो हमारे 30 फैमिली कोर्ट्स हैं आर सफिशिएंट टू सर्व द पीपल फॉर टू एजुकेट द फैमिली डिस्प्यूट्स to the people?
Yes, my take on this is that they are not sufficient at all, because today we are talking about a promise which we made in 1984. And in reality, we are living in 2026. The promise is in Section 3 and Section 9 of the Family Court Act. The reality is 30 family courts for 5 crore people in Delhi, plus NCR. The question is this enough? My answer with respect is no. If we say what was the promise of the law, in 1984, Parliament did something revolutionary. It said two things. Section 3, the state shall set up a family court for every area with more than 10 lakh people. Section 9, every family court shall promote conciliation and secure speedy settlement. Why? Because the legislature knew marriage is not a contract, it is the soul of the society. And when that soul is hurt, you don't delay the medicine. But please note, Section 3 sets a minimum, not a ceiling. It says that if we see the intent, it says at least 1 for 10 lakh. It never says stop for therefore however. So if we see the mathematics, 1984 versus 2026, 42 years. Why the math has changed? In 1984, there were 60 lakh people only. Today, it is 4 crore. We are at Gurugram, Noida, Faridabad, because people who file in Delhi court every day, and we are 5 crore. But numbers are only half the story. The bigger change is social mobility. 40 years ago, you fought with your neighbor and the elders solved it. Today, a girl from Bihar marries in Delhi, a man works in Gurugram, lives in Noida, kids study in Ghaziabad. But the case, it lands up in Saket or Tisiyari, Delhi. So NCR has become one city. Nuclear families have no home mediation left. Awareness of rights has gone up. So the 10 lakh people of 1984 and the 10 lakh people of 2026 are not the same. The burden per court has multiplied. Now, what happens when the courts are few? And this is where the promise breaks. With 30 courts, each judge is carrying, say on an average 2,500, 3,000 cases. Dates come after 2-3 months, 4 months. Conciliation under Section 9 becomes a mere formality, 5-10 minutes. The Supreme Court saw this coming. In Bhuvan Mohan Singh versus Meena, it said, delay in maintenance is denial of justice to wife and the children. So, we would carry it further in Rajneesh versus Neha, it ordered finish maintenance in 60 days. In Srinivas Rao, it said court must make every endeavor to preserve marriage. But how can a judge do every endeavor when he has 100 matters in a day? A woman from Najafgarh spends 500 rupees, 1000 rupees to reach court. A child waits 3 years in custody. 30 court for 5 crore people is like 3 ambulances for all of Delhi. The intent is there, the vehicle is not. So, what is the way forward? What is the solution? Delhi needs at least 50. So, I was on solution. What Delhi needs about 50 to 60 family courts today. One for every district plus more for high pendency areas. We need dedicated court for maintenance, dedicated court for custody, dedicated court for divorce, other restriction of conjugal right. And we need more counselors, because without them, conciliation is just a word, a mere formality. The law gives us a duty, gave us a duty in 1984. Our population, our mobility, our pain in 2026 demands that we fulfill it. Because when courts are few, justice is slow. When justice is slow in family matters, families break. And when families break, society pays the price. Let us honor the promise of Section 3 and Section 9, not as it was written 40 years ago, but as people need it today.
खन्ना साहब आपने सही कहा कि फैमिली कोर्ट में जजेस की कमी हैगी, और हम जो 10 लाख की फिगर 1984 में थी, आज उसको 2026 से कंपेयर नहीं कर सकते हैंगे, क्योंकि अवेयरनेस बहुत ज़्यादा बढ़ गई हैगी। तो इसी बात को लेकिन फैमिली कोर्ट में सेक्शन 4 फैमिली कोर्ट एक्ट में सेक्शन 4 सब सेक्शन 5 सेज द फैमिली कोर्ट जज विल रिटायर एट द एज ऑफ 62 ईयर्स, बट इन प्रैक्टिकली ये आज तक की भी इम्प्लीमेंट नहीं हुआ प्रोविज़न। आज भी फैमिली कोर्ट जज की रिटायरमेंट 60 ईयर की होती है। दूसरी तरफ रिसेंटली सुप्रीम कोर्ट ने कहा है कि डिस्ट्रिक्ट जजेस की रिटायरमेंट एज 60 से बढ़ा के 61 कर दी जाए। तो एक तरफ जहाँ जजेस की कमी हैगी, जिस स्केर्सिटी के कारण जो फैमिली कोर्ट के ऑब्जेक्टिव हैं वो हम 40 साल बाद भी अचीव नहीं कर पा रहे हैं बिकॉज ऑफ द स्केर्सिटी ऑफ जजेस। सो वाई दिस प्रोविजन हैज़ नॉट बीन इम्प्लीमेंटेड बाय द गवर्नमेंट टिल डेट, एंड व्हाट इज़ योर suggestion?
Yes, this 60 we know in traditional setup, superannuation age is 60 and family court speak about 62. But overall, if we see in family courts, not only judges from available pool of judges come, they can also come from outside because it is a different mindset, different requirement of the Family Court Act. So what is being done is that experience, what is required is that experience which a family judge gains after working for 3, 4, 5 years, that requires to be utilized. So after working on a say in Delhi now, we don't have that special roster judges working only on the family side. They come from civil side, criminal side, working for 2, 3 years. And of course, earlier, I think when we joined as family judges, initially some sort of interaction used to be done to see the mindset, to see the capacity, how whether a judge will be able to do justice to the Family Court Act provision. But now I'm not aware if it is being done. It should be done. And the age, of course, should be 62. That experience which is being lost, that has to be utilized. So my view is yes, 62, both for family court judges at least it should be there. If it increase for other court and not, that is a different thing for that.
Okay.
Thank you.
तो फैमिली कोर्ट की फाउंडेशन जो है वो है काउंसलर्स, एंड सेक्शन 6 ऑफ द फैमिली कोर्ट सेज द स्टेट गवर्नमेंट इन कंसल्टेशन विद द हाई कोर्ट शैल डिटरमाइन द कैटेगरी एंड नंबर ऑफ काउंसलर टू असिस्ट फैमिली कोर्ट, एंड रूल 9 ऑफ दिल्ली फैमिली कोर्ट रूल्स सेज दैट there shall be one principal counselor and not less than 2 counselor with a family court, meaning thereby each family court should be assisted by at least 3 counselor. But presently we have total 30 counselor, whereas we should have 90 counselor. अगर हमारे पास जजेस की कमी है कि काउंसलर की कमी हैगी, तो जो ऑब्जेक्ट है फैमिली कोर्ट एक्ट का जो 1984 में फिक्स किया गया था, उसको हम आज 2026 में 40 साल बाद कैसे अचीव करेंगे?
बिल्कुल ठीक कहा आपने कि काउंसलर्स जो हैं एनफ नहीं है. वी नीड मोर काउंसलर एज रिक्वायर्ड. सेक्शन 9 clearly says each court should have at least 3 counselor. I think 1 principal counselor and 2 other counselor. But in practice, actually, we see there are hardly 3 counselor for each court. There are only 1 counselor, and that what happens because of passage of time, that counseling, that conciliation effort becomes a formality. So we, of course, by that logic, we need 90 counselors. So now, to how that is, firstly, more counselors are required, and then of course, because family disputes are not like other disputes. They need healing, not adjudication. I've already mentioned about that. So to do with that, of course, we have mediation centers and private mediators can be roped in, but that is not that will only should supplement. But what we require is appointment of more counselor on permanent basis. That is the only requirement if we want to really achieve the objective of the Family Court Act.
और जो आज 30 जो काउंसलर हैं, ये भी कॉन्ट्रैक्ट बेसिस पर भी हैंगी. ये काउंसलर की बहुत समस्या रहती है कि उनका कॉन्ट्रैक्ट रिन्यू होगा नहीं होगा, वो टाइमली कभी रिन्यू होता है कभी नहीं होता है. तो इनमें भी एक अनसर्टिनिटी बनी रहती है, जिसके कारण से वो अपना पूरा जो टाइम और पूरी एनर्जी के साथ वो डिवोट नहीं कर पाते रेजोल्यूशन में.
Yes, it is true. Yeah. It is true that the counselors in Delhi, as we know, are not appointed on a permanent basis, and they are on contract basis every year to year. That is being extended. Security of tenure of the counselor is required, so that they can focus their energies on their work in conciliation instead of worrying about whether their contract would be extended or not. So of course that is the one thing which needs to be plug out. So counselors should be appointed on permanent basis, and that is a way out to, if we want to achieve the objective of the act.
अब काउंसलर की कमी हैगी, पार्टी प्रेशर बनाती है कि हमें आप तारीख छोटी दीजिएगा, मीडिएशन कराइएगा, तो कोर्ट्स जनरल उनको फिर मीडिएशन सेंटर में भेज देगी. दोज आर ऑलरेडी ओवरबर्डन इसलिए हैं क्योंकि इनके पास सारे कॉग्निजेबल जो कंपाउंडेबल ऑफेंसेस हैं वो पहले से 130 के डे और दूसरे कंपाउंडेबल ऑफेंसेस आते हैं, जिसके कारण कि मीडिएशन सेंटर ऐसे ओवरबर्डन हैंगे. तो ऐसे में ओवरबर्डन इंस्टीट्यूट को जब रेफ़र करते हैं मीडिएशन में फैमिली डिस्प्यूट, तो वो ओवरबर्डन हो जाते हैं, कोई रिजल्ट निकल नहीं पाता है, इफेक्टिव जो ऑब्जेक्ट है वो हम अचीव नहीं कर पाते हैं. तो ऐसे सिचुएशन में क्या सिस्टम को प्राइवेट मीडिएशन को प्रमोट नहीं करना चाहिए?
Yes, I agree. Private mediation, now the time has come when private mediation has to be promoted, because the availability of counselors and mediation is not fitting the bill. Section 89 we know says about, and the mediation rules say that mediation is there, and the court next mediation center we have. The new Mediation Act 2023 which had been enacted, but that has still not been notified. So because Mediation Council of India has yet not been formed. Otherwise those private mediator those service providers had to be registered with the Mediation Council. So we do not know why that has not been done. So private mediation is the answer, because private mediator will now fill that gap which is existing. To for example, say counselor today has 15-20 cases lined up, you get hardly 10 minutes. She can't do conciliation in 10 minutes. A 10-year marriage in 10 minutes, 15 minutes, with children involved. So mediation center, I'll say there's no dispute, they are doing great work, but they are overburdened. If a couple who is in conflict gets a date after say 2 months or 45 days, what happens? Tempers by that time are hardened. I've seen cases where parties went to private psychologists or senior advocates for mediation of their own, and many times they settled in 2-3 sittings. Why? Because there was time, privacy and flexibility. The problem is not about the intent. We are not questioning the intent. The problem is bandwidth. So system should invite private mediator. My view is in matrimonial matters, yes, but with safeguards. Because those mediators have to be like arbitrators or other court and mediator, they have to be empaneled. Now the mediation center or the high court can create a panel of accredited private matrimonial mediators with training, of course, in family law, experience in psychology, in child welfare. So the court control should be there then. The judge refers the case, sets a timeline of 60-90 days, and the mediator reports back. The settlement still needs court approval. So judicial oversight would be there, would remain there, even in case of private mediator. And choice plus access now. We're talking about choice and access. Parties who can afford private mediation may opt for private mediation to get earlier dates. Parties who cannot continue with the free court counselor and the mediation center, they are not excluded. No one is excluded. Because this is already working in commercial dispute. There's a reason it can't work. There's no reason why it can't work for families. If we can regulate it, when? The goal of Section 9 is not who does the mediation. The goal is, does the marriage gets a fair chance? Does the child get stability early? So I think we need 3 things to work together. More counselors as per Section 9, strong mediation centers, and a regulated and panel of private mediator to add capacity. Because when a family walks into court, they are not looking for 3-year fight. They are looking for a closure with dignity and a way forward. If we add capacity with proper safeguard, we honor both the law and the litigant, because speed without quality is not justice, and the quality without speed is also not justice.
और सिस्टम से जब बात की जाए, सिस्टम में आप उनकी ये प्रॉब्लम है कि हमारे पास इंफ्रास्ट्रक्चर नहीं है। जितने मेडिएशन सेंटर हैं वो ओवरबर्डन हैं, वहाँ रूम्स अवेलेबल नहीं है, स्टाफ अवेलेबल नहीं है। तो जब आप प्राइवेट मीडिएटर को, जैसे आपने कहा कि रेगुलेटर होने चाहिए, रेगुलेशन इन सेंस कि जब आप वो जो प्राइवेट मीडिएटर हैं दे शुड वर्क अंडर द मेडिएशन सेंटर। जब आप उनको पैनल पे लें तो आप उनको देख लीजिए जाके कि इंस्पेक्शन कीजिए वेदर दे हैव फैसिलिटी टू मीडिएट और नॉट। इफ यू फाउंड दैट दे हैव सफिशिएंट इंफ्रास्ट्रक्चर, दैट प्राइवेट मीडिएटर, देन यू कैन इम्पैनल देम and they will work under your guidance and under your supervision. So by that doing that, the system is not required to invest more money to create the infrastructure. The infrastructure created by the panel mediator can be utilized to conciliate, to mediate matrimonial dispute between the parties.
Yes, it is true, because we see there's a lack of infrastructure and resources. That is why that gap is being fulfilled by job is being done, has to be done by the private mediator. So once those mediators are empaneled, and of course when they would be empaneled, there would be supervision, some supervision, inspection of the concerned person, supervisor or the judge in charge, etc., to see whether that mediator has that necessary infrastructure and the capacity to do that. Of course, only thereafter they would be accredited. And of course that control of time and would be there. So that supervision has to be there. It can't, that is a safeguard.
और खन्ना साहब, फैमिली कोर्ट की एक जो जनरली शिकायत रहती है लिटिगेंट की कि आप फैमिली कोर्ट पहले तो मेंटेनेंस फिक्स करने में डिले, मेंटेनेंस फिक्स हो जाए तो उसकी एग्जीक्यूशन में लिटिगेंट को बहुत परेशानी उठानी पड़ती है। तो क्या ऐसे सिस्टम होना चाहिए कि जो मेंटेनेंस की एग्जीक्यूशन है वो एट द अर्लीस्ट हो विदाउट एनी डिफ़िकल्टी?
बिल्कुल होनी चाहिए, क्योंकि एक जैसे मैंने शिकायत जो मैं हर फैमिली कोर्ट में सबसे ज़्यादा सुनता था वो ये थी कि सर मेंटेनेंस का ऑर्डर तो हो गया लेकिन पैसा अभी तक नहीं आया, पैसा कब मिलेगा? ऑर्डर मिलना एक बात है, एग्जीक्यूशन होना दूसरी बात है। आज बात अगर हम करें एग्जीक्यूशन की, तो अगर हम देखें इसको मैं तीन चार पार्ट्स में, 4 सेगमेंट में डिवाइड करता हूँ बात को, आंसर को। सुप्रीम कोर्ट ने हमें एक क्लियर रोड मैप दिया। रजनीश वर्सेस नेहा 2020 में सुप्रीम कोर्ट ने 12 डायरेक्शंस दी। सुप्रीम मोस्ट इंपॉर्टेंट थी कि मेंटेनेंस मस्ट बी डिसाइड इन 60 डेज, और ऑर्डर के बाद एग्जीक्यूशन शुड ऑल्सो बी टाइम बाउंड। इट सेड कोर्ट मस्ट इंसिस्ट ऑन एफिडेविट ऑफ असेट्स एंड लायबिलिटी फ्रॉम बोथ साइड एट द वेरी फर्स्ट स्टेज। भुवन मोहन सिंह में वर्सेस मीना 2015 में सुप्रीम कोर्ट ने कहा कि डिले इन मेंटेनेंस इज डिनायल ऑफ जस्टिस टू वाइफ एंड चिल्ड्रन। दे हैव नो इंडिपेंडेंट सोर्स ऑफ इनकम। इनह्यूमन कंडीशन इन 1387 प्रिजन 2016 में सुप्रीम कोर्ट ने डायरेक्शन दी कि एग्जीक्यूशन में कोर्ट शुड यूज कोर्सिव स्टेप क्विकली, वारंट्स, अटैचमेंट, इवन सिविल डिटेंशन इफ नीडेड. So there's no reason why these provisions should not be used. The law and intent is already there. Challenge is implementation. So where delay happens, now 3 problems crop up. Tracing income. Husband says I am jobless, but he has bank accounts, property or salary. Without asset disclosure, the court is blind. Multiple proceeding. Same maintenance is pending in 125, Domestic Violence Act, Family Court. Time gets wasted. In which court will execute? Execution is treated as secondary. After the main order, execution files gets old dates. Meanwhile, rent, school fees, medicine, they don't wait. So, what can the system do? I'll say 5 steps which already judgments have mentioned can be scaled. 1. Assets affidavit at filing stage. Follow Rajneesh versus Neha. Take bank details, salary slip, ITR, property details on day 1. If someone hides assets, it is perjury. That itself speeds up the compliance. Number 2. direct attachment. Instead of waiting for warrants, court can directly order attachment of salary, bank account, or attach property under Order 21 CPC. Many family court in Delhi are now doing this. Nodal officer model. Appoint a court officer who tracks execution. One call to employer or bank and money is deducted at source. It can be done. Time-bound execution list. Keep a separate execution board every week, not once in 2 months. Bhuvan Mohan Singh says it is a matter of survival. Link with government database. PAN card, Aadhaar, EPFO, bank. If the system can quickly pull income data, I am jobless argument fails. So, to close it, maintenance is not alimony, it is food, maintenance, school fees. When a woman wins the case but waits for 2 years for money, she wins on paper but loses in life. So, to combine three things, Rajneesh, disclosure, quick attachment, and dedicated execution dates, we can take execution as fast as the order itself. Because an order without execution is like a prescription without medicine. And in family matters, order is not just legal, it is personal. So let us make sure that when the court says you will get maintenance, the system ensures you will get it on time. This is what I have to say on this.
Khanna Saab, technology has bring transparency and efficiency in the judicial system. And because of the technology, now the litigant can download every order, single order passed by any court, including district court, high court, or the Supreme Court. Rule 17 of Delhi Family Court says that only the first letter of the name of the party needs to be mentioned in the judgment. When there is a rule that the judge will not mention the particulars and name of the parties, which may disclose the identity of the parties. Now, why the parties are deprived from the benefit of technology in the family to the family court litigants?
Yes.
Because now the litigant has to apply for the certificate copy of each and every order, whether it be maintenance or a journal order or the judgments. It consumes a lot of time.
Yes, it is a very significant question you have asked. This question is often asked, that why family court judgments are not fully online. Litigant ask this question. So today we all file RTI and check civil and criminal orders online. It brings transparency actually, saves time and reduces adjournments. So but people ask me, family court ke order online क्यों नहीं मिले? Is it denial of a right? I think let us understand. Family courts are different by design. Of course, and privacy is the core object. The entire Family Court Act 1984 was made to keep family dispute private and dignified. Rule 17 of Delhi Family Court Act, Rule 2024, captures this. It says in judgments, only the first letter of the name of the party shall be mentioned. Example A versus B instead of full name. Why? Because here we discuss maintenance, custody, domestic violence, mental health, children. Publishing full detail online can affect a child's future,
Yes.
a woman's safety, and the reputation of both families forever. So, the Supreme Court in Nandkishore versus State of Maharashtra 2022 also said, right to privacy under Article 21 includes privacy of matrimonial disputes. So, we have to balance that transparency versus confidentiality. Are litigant deprived? Not exactly. The system is balancing two things. Transparency for parties. Any party or lawyer can get a certified copy of their own order the same day from the court. And confidentiality for family. To protect children and parties from public exposure, full judgments are not uploaded like other courts. That is why family court were kept out of the general open data portal model. And the way, but what is the way forward? We see, we can still bring efficiency without hurting privacy. How? Secure party login like income tax portal. allow only parties to download their own orders using case number plus OTP. Number 2, redacted judgments. Upload judgment with names masked as per Rule 17. So researcher and lawyers can see the legal reasoning. As third, SMS and email alerts for dates and order status. So litigants don't have to come to the court repeatedly. So the reason is not to deprive. The reason is to protect. Family courts deal with broken homes, not just broken contract. Transparency is, of course, important, but dignity is equally important. If we use technology with redaction and secure access, we can have both.
खन्ना साहब ने सही कहा कि पार्टी को अगर लॉगिन दे दिया जाए तो कम से कम पार्टी तो अपनी जजमेंट डाउनलोड कर ही सकती है एंड दे कैन मेंटेन दी प्राइवेसी ऑल्सो. बट एज ऑन डेट अगर कोई स्टूडेंट है वो रिसर्च करना चाहता है कि वाई द फैमिली ऑन व्हाट ग्राउंड द divorce are increasing or decreasing, or what is the approach of the courts, then how will conduct the research in the absence of the data. So all data should be available on the platform. When we are saying the rule says you will not mention any fact which may disclose the identity of a person. So it's also deprive the research on topic.
Yes, you rightly said, because researchers need legal reasoning. The names are masked as per Rule 17. They can do all the research and it can be done fruitfully. And of course, having regard to the dignity and the transparency, as I said. And that is what I had to say. And if you allow me to sum up in nutshell, 2-3 minutes, I'll say, and the big picture we see is that the family courts are not for winning or losing. Section 9 of the Family Court Act says the goal is conciliation and speedy settlement. But 3 realities which hit us: too many cases, too few hands, and too much emotional damage while we wait. So the latest judgment which we referred, they guide us. I'll not repeat. Supreme Court has given the roadmap in the last few years. I'm not repeating those judgments again. The big challenges today are the capacity gap. Rule 9 says 3 counselors per family without enough support itself. Section 9, conciliation becomes rushed. Execution gap, order comes, money doesn't. Tracing income is the biggest hurdle. Multiple cases, one dispute run into 4 courts. 125, DV, 490-day, family court, time and money is wasted. Privacy versus transparency, as lastly we discussed. Families need confidentiality. Rule 17 of the Delhi Family Court, Rule 2024 says only first letter of the names of judgment. So full name upload isn't possible. The way forward is, if we do 5 things, I say, we can fix 80% of the problem. Early disclosure, 100% implementation of resignation affidavit, assets on file, faster order, faster execution. Scale mediation, strengthen in-house counselor, add regulated panel of private matrimonial mediators under the control of the judge in charge, mediation center or the high court, more hands, earlier dates, more settlement. Smart execution, weekly execution board, direct attachment of salary, bank, use of EPFO, PAN data, Bhuvan Mohan Singh model. One window disposal, club all maintenance claims, discourage parallel proceeding. Technology, tech with privacy, secure party login to download orders, redacted judgments for research, SMS alert for dates, follow Rule 17. The law wants speed. The judgment demands sensitivity. The litigant needs both money and dignity. Speed without quality is injustice. Quality without speed is injustice too. If we combine Rajneesh disclosure, more mediator, fast execution, tech with privacy, we can make family courts truly deliver on their promise. Settle early, settle fairly, settle with dignity, because a family dispute is not a file, it is life. Thank you.
खाना सर, एक लास्ट क्वेश्चन है कि फैमिली कोर्ट में आपने काम किया, मैंने भी काम किया है. फैमिली कोर्ट का एक सब्सटेंशियल टाइम जो चला जाता है कि म्यूचुअल डिवोर्स में चला जाता है. म्यूचुअल फर्स्ट मोशन, सेकंड मोशन. क्या ये पॉसिबल है कि सेकंड मोशन को हम ऑनलाइन कर लें, कि पार्टी अपना ऑनलाइन सेकंड मोशन फाइल करे, दोनों पार्टियां अपीयर हो, वहीं पे उनके लॉगिन के एट कोर्ट आवर्स, आफ्टर कोर्ट आवर्स और इवन वीकेंड के बाद हम उनको ऑनलाइन हियरिंग देके ऑटोमेटिकली डिक्री जनरेट हो जाए विद डिजिटल सिग्नेचर ऑफ द जज, दैट कैन पार्टी डाउनलोड. Is it possible? Or the system can think about that?
Yes, to some extent, I agree with you. Online, of course, online hearings are held. But since you have asked only about the second motion.
Only second motion, because in first motion, court has to satisfy whether the party should be allowed to go for the time or not. But once the first motion is allowed, then becomes the second by virtue of the certain judgments of the Supreme Court. The second, if there is a court is not bound, parties are not bound to wait for a particular period. That period can be condoned.
Yes, but I'll say as a rule, I don't think as a rule we should do this, that in every second motion should be online, because you see the two motion, they have an objective. First motion, court grants time to the parties to see whether so that they reflect upon, they think over it, and then they come again. Because when they come again, then again court hears them, satisfies that yes, now the reconciliation is not possible and the parties have to part their way. So I think again it will depend upon the specific fact situation. We can't make it as a rule that it should be online second motion. So it again depends upon the specific fact situation. It can be done, yes. But it is not necessary that in all cases should be done.
Not in all cases, certainly not in all cases. Thank you, Mr. Khanna.
Thank you very much. It's my pleasure.
Thank you.